welcome. I'm Lisa Jordan. I'm the director of the Maryland Coalition Against Sexual Assault, and I'm delighted to welcome you to Lunch and Learn on digital stalking, safety planning, and new laws. Let me introduce our panelists. First, we'll have Debbie Feinstein. Debbie Feinstein is the chief of the Special Victims Division at the Montgomery County State's Attorney's Office. She's joined by Tiffany Watson, our fabulous managing attorney at MCASA's Sexual Assault Legal Institute. And Maddie LeClure is our prevention and education policy advocate at MCASA. The Maryland Coalition Against Sexual Assault works to prevent sexual assault, advocate for accessible, compassionate care for survivors of sexual violence, and we also work to hold offenders accountable. We were so glad to be part of a large coalition of advocates for survivors of sexual assault and domestic violence who passed laws this year to improve stalking. Not improve stalking, improve the stalking laws. There are changes in the laws that will help both with civil cases and also with criminal cases. The Sexual Assault Legal Institute provides services for survivors all across the state of Maryland, and they handle civil protective orders and other cases that help survivors. They'll be using the new stalking law to help survivors in civil courts. The state's attorney's office helps in criminal cases. Every jurisdiction in Maryland has a state's attorney's office. Their primary responsibility is investigating and prosecuting criminal defendants, but they also really serve the public interest through fair and honest administration of justice, making judgments to address inequality, the criminal justice system, and educating the public on criminal justice issues, working to prevent crime. And today's training is an example of that sort of work. Let me turn things over to Maddie LeClure next. Note that if you have questions about something that comes up during the training, please put it in the chat. Everyone on this program will receive answers to those questions. We'll email them out separately. Also know that this presentation will be available on MCASA's online training platform, so you can share it with anyone who missed it today. Maddie, over to you.
Great, thank you. We just want to start off today with a little bit talking about the prevalence of stalking. An estimated 13.5 million people are stalked in a one-year period in the United States. More than twice as many survivors of stalking are stalked with technology than without, highlighting how digital stalking is a huge issue for survivors. And stalkers use many tactics for digital stalking, including making unwanted phone calls, sending unwanted texts, photos, emails, and messages through social media, and using technology to monitor, track, or spy on the victim survivor. There's also a large correlation between stalking and sexual violence. As just one example, that nearly 1 in 3 women stalked by an intimate partner were also sexually assaulted by that partner. So this is a major issue, and we are looking forward to talking with you all today about the changes in the law that will support survivors of digital stalking. And with that, I will turn it over to Debbie.
Good afternoon. As Lisa mentioned, I am a prosecutor with the Montgomery County State's Attorney's Office, and part of our responsibilities is to prosecute cases involving stalking. My division specifically handles stalking cases that are related to intimate partner violence or other sort of things that fall into the special victims bucket. I had the privilege of participating in some of the legislative work that was done this year to improve the stalking statute. What you're seeing on the screen before you right now is the current language of the stalking statute, section 3-802 of the criminal law article in Maryland. So stalking can be proven in 2 different ways right now, really. So it's a malicious course of conduct in both. In category number 1, it's approaching or pursuing another person, where the person intends to place or knows or reasonably should have known that the conduct would place another person, so the victim, in reasonable fear that they or a third party, like a family member, a friend, something like that, will suffer serious bodily injury, assault, rape or sexual offense, false imprisonment, or death. A few years ago, category number 2 was added, which is a malicious course of conduct that includes approaching or pursuing another where the person intends to cause or knows or reasonably should have known that the conduct would cause serious emotional distress to another. I would mention that approaching or pursuing does not necessarily mean approaching or pursuing in person. In the world that we live in now, approaching or pursuing can include any number of ways that can be accomplished electronically through surveillance, air tags, that sort of thing. So approaching and pursuing, or really pursuing, can be defined in many different ways, and we've been successful at prosecuting cases in that regard. The new language this year, which goes into effect on October 1st, 2022, is to really kind of drill down and specify the definition of stalking. Stalking includes conduct that occurs in person by electronic communication, which is defined in 3805 of the criminal law article, which also includes email, texting, Facebook messaging, Instagram messaging, Snapchat, et cetera, et cetera, et cetera. And then also through the use of a device that can pinpoint or track the location of another without that person's knowledge or consent, an AirTag or any other kind of tracking device. Now, I highlighted the word includes because stalking is not limited to these three things. We see stalking that's done by letter, through and other means that are not necessarily electronic and not necessarily in person. Because as you saw in the previous definition, and it can also sort of be accomplished through a third party in other ways, although the threats also can be made towards third parties, as I was indicating before. But just to know that although this specific definition has been added to really, again, make clear that electronic communication and tracking devices are included in the definition of stalking, it doesn't eliminate sort of other ways that we've looked at to prove stalking, and it doesn't eliminate other means that are not specifically delineated, if that makes sense. Next slide, please. One of the most important things about stalking, and this goes for whether we're looking to demonstrate stalking in a civil case when someone's seeking a protective order or peace order, or whether you're trying to seek actually, I guess it would just be a protective order because stalking is included, as will be discussed later, but or a criminal case involving stalking. It becomes really important for individuals that are or believe they are being stalked to document what is happening to them. And some of the documentation strategies include taking screenshots, keeping an incident log of all communications, whether that's text messages, social media posts, emails, phone calls, voicemails, and any of those in-person contacts or old-fashioned letters. Sometimes we'll see people leaving notes on, on someone under the windshield of someone's car, or dropping something through the mailbox that may not be, specifically mailed through the mail, but leaving notes, Post-its, other things at someone's office, someone's home, a place that someone may go often, that sort of thing. Another way to do this is to use another camera to gather messages or photos that disappear automatically or might alert the sender when a screenshot is taken. So that's like Snapchat. If you screenshot something that's sent to you via Snapchat, it may alert the sender that that screenshot is being taken. So using another camera or another phone to take those photos is really important. Also screenshotting text messages and other things, as was described a moment ago, really important to screenshot or to take photographs of that. And also to collect phone records from your phone company that may show frequent and repetitive calls from the perpetrator. Some of the things that we can do through the state's attorney's office and through various subpoenas is also to figure out where the person might have been when they were making those calls, or when they, when the victim may have believed that they were going to see them. We can do things with cell phone location, geofences, other things to try to figure out where people are when they're, when there's concern that they're stalking. Now, some of the digital stalking tools include, as we've discussed, GPS devices, spyware, cameras, hacking into devices in account, or accessing devices without consent. So if they're able to figure out your password or know the person's password, that sort of thing may result in accessing devices without consent. And that's why sort of all of these, it may not be electronic communication per se, it may not be tracking devices per se, because it may be someone that's not communicating directly, but accessing the private messages that someone is sending. And that's going to be included within stalking as well, because that is included in the definition of pursuing. And again, we've been successful in doing that as well. If we can go to the next slide. So here's a sample documentation log. It's really important for individuals who are being stalked to really gather as much data and information as possible. Why is this important? Because if ultimately they make a decision to report it to the police, having this information is going to be really helpful. Stalking cases are often investigated or looked at by police officers who are, there's patrol officers, and then there's officers who are detectives. And stalking, because it's a misdemeanor, may often be looked at by a patrol officer who may not have the time or expertise to kind of gather all of this very specific information or be able to kind of issue all the subpoenas. So I'm going to talk in a moment about why it's important to also connect with offices like mine. But the most important thing is to document everything that's happening in real time. Because if an individual is being stalked comes forward with this information, it'll make it a lot more straightforward to really look into the details, to issue the subpoenas that we need to issue. It'll also make it much more helpful if the person decides to pursue a civil protective order, because all the information will be laid out in great detail, again, in real time. It won't be sort of a need to go back and kind of refresh or to remember what might have happened, and it becomes a lot more substantial and clear evidence when it's documented in real time, or as real time as can be gotten. And I think what we see a lot in stalking cases is that people aren't really sure whether they want to go to the police. They aren't sure if it's actually stalking. They're not sure, if it's going to keep happening. That's why documenting everything that happens becomes really important. Next slide, please. This is another behavior log, stalking incident. Really, it doesn't matter how it's done. These forms are not required. A piece of paper, notes in your phone, anything. It doesn't really matter as long as the documentation is done and that these screenshots are taken, that things are captured and saved in a way that might be able to be utilized down the line. Next slide, please. And here, back one, I'm sorry. So here's an example of a filled in evidence chart, or a stalking log. The dates that it happened, what happened, the evidence that it happened, who you think did it, evidence that they did it, and evidence still needed, and who has it. This may be something that someone in my office may utilize to really, again, drill down on all of those details. But if any of those boxes can be filled in by the individuals that's being stalked, great. And again, here there's, this person or this sample includes like website URLs, other links, attachments, all really important. And it's asking a lot of someone that's surviving and living with stalking, but because of the nature of stalking and because it's an ongoing course of conduct, this type of information becomes critically important for us to be able to pursue a criminal case. Next slide, please. I mentioned a moment ago that there's different ways to report a stalking crime. It can be reported directly to the police by walking in, by making a phone call. That's one way to report a stalking crime, and to try, to meet with an officer. Maybe it'll be assigned to a detective. Also, to apply for another alternative is to apply for charges at the commissioner's office. So this means someone going in themselves and taking out the charges. So for example, say it's reported to the police and the police say, we're not sure if we have enough information, or the person doesn't even want to go to the police and wants to just apply for charges directly. They can go directly to the commissioner's office in their jurisdiction and write up basically a statement of charges, write out a statement of what happened. To be honest, I want to just sort of be clear, our preference, if someone's looking to file criminal charges, is to go through the state's attorney's office or to go through the police. I think that's really important because that way the person isn't responsible for writing up their own charges, which becomes another statement of what happened to them. They may not put in all the details. And then later when they're going to be prosecuted, it may be that, when the case is going to be prosecuted, they could be questioned about what they included, what they didn't include in the statement of charges. And so if someone is comfortable, even with an advocate, going and talking to the police or contacting a state's attorney's office in your jurisdiction. So when a stalking case comes into my office, my division, the Special Victims Division, looks at it. So we have specialized attorneys. We have paralegals on our team. We work with investigators within my office. We take these cases incredibly seriously. And I know a lot of other jurisdictions handle things in the same way. And then lastly, know that a protective order is always an option as well. Thank you so much.
Thank you so much, Debbie. I'm going to cover civil protective and peace orders. So I'm going to cover basically the basics around protective and peace orders. And I'm going to talk about a couple things that are specific to stalking. So the first slide here, just generally types of protective and peace orders, starting with an interim order, which is an order that is issued by a commissioner when a petition is filed with their office, and it's effective for about 2 days if the temporary order doesn't happen before then. The temporary order is issued by a judge after a hearing, and that's effective for 7 days after service. Final orders are issued by a judge also after a hearing. Final protective orders are effective for 1 year, though there are exceptions to this rule. And final peace orders are effective for 6 months. Next slide, please. So the process to file a protective or peace order. When courts are open, a petitioner can file for a temporary order at the district court or the circuit court. And when courts are closed, a petitioner can file for an interim order at the commissioner's office. And those are just the hours of the court and just some other details showing that at the commissioner's office on weekends, nights, holidays, things like that. Next slide, please. Thank you. There's also some new legislation that will be effective October 1st of this year, involving virtual access to temporary protective order proceedings. So the new legislation authorizes a petitioner who is receiving medical treatment at a hospital to electronically file a petition for a temporary protective order while in the hospital or at certain program centers. And it requires that court that's receiving the filing to hold a virtual hearing the same day or the next business day. Next slide, please. So to be eligible for a protective order, there must be a specific type of relationship or also sexual offense will qualify someone. And I'll just go through the list here on the left hand of the screen. So a sexual offense within the past 6 months, current or former spouse, the petitioner and respondent are related by blood, marriage, or adoption, sexual relationship between the petitioner and respondent within 1 year before filing the petition, cohabitants, and the petitioner is a vulnerable adult. So anyone who does not fit in those and fits under all other relationships, including neighbors, strangers, non-sexual dating relationships, should file a peace order. And I want to note that if the petitioner's relationship qualifies for a protective order, they have to get the protective order. They can't get the peace order just by choice. Next slide, please. So what acts of abuse qualify? Peace and protective orders have a requirement for specific acts of abuse, and they also share some acts that qualify. For the sake of time here, and you can read them on the screen, I'm not going to go through the entire list here. I'm not going to just read them off for you, but I do want to note that the definition of stalking that now includes the use of tracking devices is quite helpful because it can be difficult to persuade a judge to believe that use of a tracking device alone could place someone in fear of imminent serious bodily harm. Though I think that you can make really strong arguments to establish that, but including that type of use and the definition of stalking is really helpful to establish that act for a protective order or peace order. Next slide, please. So forms of relief. The list that you see here on the screen, most are specific to protective orders, such as the order to vacate a residence, custody and visitation conditions, and emergency family maintenance. Many peace orders will simply provide stay away and no contact provisions and counseling. Under the catch-all that you see at the bottom of the screen, where it states any relief necessary to protect, which is the catch-all provision there, it would be prudent for stalking victims and those who are assisting them, practitioners that are assisting them, to include provisions such as prohibited use of tracking devices, prohibited use of a certain social media website or other virtual platforms, in order to make sure that those sorts of acts that are specific to what gave rise to the Stalking Act in general is included and clear for the respondent. Next slide, please. And I will turn it over to Maddie for safety planning. Thank you.
Great, thank you. And Debbie covered a lot of safety planning tips with the documentation strategies as well that can be helpful for advocates and those working with survivors. Just a few more things we wanted to note about safety planning specific to digital stalking and technology abuse. It's important to determine the most secure and safe way to communicate with the survivor throughout the process as you're determining what forms of technology are being abused and maybe used to stalk the victim, of making sure that you're finding the most safe and secure way to be able to communicate with them. We also want to make sure that we can provide the survivor with tools to strategically plan their tech use, which might include things like changing passwords, updating their devices, maybe getting a new phone, adding in additional security features, and monitoring their social media, looking through their friends list, things like that. That can support them with feeling safe in their tech use. And we also want to be able to empower the survivor to take back that control and choice about their tech use that might have been taken away due to the digital stalking. And it's also important to revisit and update safety plans with the survivor as circumstances change. So for example, the perpetrator might be using a new form of technology to stalk if a password was changed and they're no longer accessing one account. They might be trying to get information through a different platform and keeping track of that, as well as updating safety plans. Maybe the survivor has relocated and that is causing different circumstances, or maybe the survivor's child has started at a new school. Just different situations that might come up as you're working with the survivor and making sure that that safety plan is up to date with the form of technology that's being used. And there's also some great tools out there for assessing for tech misuse. The National Network to End Domestic Violence has a whole site on tech abuse and this tool on steps to assessing tech misuse and safety. So this three-step process is prioritizing safety planning. So talking to the survivor about what are their current safety concerns, what are their fears about things that the perpetrator might know, what information do they have that they shouldn't have, things like that. The next step would be narrowing down the possible technology that could be used. So what types of things have happened to the survivor that are causing them to feel unsafe or causing concern through technology. And then lastly, three, engaging the survivor's knowledge and understanding. So talking through with the survivor how they think this is happening. Is it something to do with a cell phone? Is it a shared computer? Is it a child monitor or a camera system in a home? Talking through so they can figure out as well the best next steps for increasing safety. And these are the references we use throughout the presentation. As I said, and as others said, there's lots of great resources here. All of the sample safety planning document logs are on this as well, and we'll be sure to send this out in the follow-up as well. And Meredith is going to pop an evaluation in the chat for everyone as well to help us improve our training. If you have a moment to fill that out, that would be greatly appreciated. And then here is, as well as the Sally contact phone number where you can contact the Sexual Assault Legal Institute for support for clients and survivors and any other needs you might have or further information on learning more about this update to the stalking law. And if we have a few moments for any questions, we are happy to take those.
All right, thank you, Maddie. If maybe I can just say thank you to everyone for spending lunch with us. We really appreciate having your presence and your attention. We're very excited about these new laws that relate to technology. The one that will give our prosecutors and our civil protective order and peace order attorneys another tool, and then another that will give survivors a tool once those programs are up and running. I know Tiffany mentioned the virtual protective orders. We're all very excited about that, and the General Assembly has authorized programs in hospitals to offer that. It's not mandated yet, but that will be another lunch and learn, I believe, in conjunction with the Maryland Network Against Domestic Violence, who really helped lead the fight for that. So I know both coalitions will be doing some training, and I imagine working together. So please keep your eye out for that. And thank you again for joining us for your lunch hour. Let us know if you have questions, either by popping them in the chat right now or emailing us directly at info@mcasa.org. We're always happy to help and provide technical assistance. Thank you to the panelists. You were fabulous as always. And everybody, enjoy the rest of your day. Stay cool in the heat wave.